Once a month, we get an opportunity to sit down with our local prosecutor, Twin Falls County Prosecutor Grant Loebs, and we take some time out, have a Q&A with him about issues that are impacting, frankly, the legal system. And in many cases, some of that is local, some of that is actually things that are going on around the country, but obviously they have a bearing sometimes on what happens legally when you talk about precedent setting and the like. And of course, the prosecutor is available to take your telephone calls as well this morning. Question or comment for him, 736-0300. Bill Colley with you as well. It's 9:07 and 64. First of all, welcome back. Long time no see.
Thank you. Good to be here.
I know you've been a busy man this summer. Is there a vacation at any point?
Well, I actually was out of town on a part vacation last week, so
Part means you were working.
part means I always have my cell phone and I'm always on it. And if I'm vacationing, people say put your cell phone away, and I say, well, but I could get an important call, and so that's the way it is when you have this job, and that's fine.
Two big stories while you've been away from the radio that I was tracking over the course of the summer, which I think show you the proper way to go after an investigation of a case versus an improper way. What happened in Baltimore, Maryland, where Marilyn Mosby, the state prosecutor,
Mhm.
seems to have fumbled in her attempt to prosecute six police officers in the death of a fellow by the name of Freddie Gray. And I was comparing and contrasting that with the work that Lawrence Wasden did on the council shooting that
Right.
happened in November 1st, where there is a stack of evidence. First of all, where did Mosby go wrong with what she was doing?
Well, I think she went wrong in a lot of ways. Number one, and well, at the outset, first of all, I don't know all the facts. I don't pretend to know everything that she might have known. She is a relatively inexperienced prosecutor, and I think that that's a fact. I think that she was under a lot of political pressure to make decisions and to make decisions quickly in that case. There was, as we all recall, a lot of rioting. There were police cars being burned. There was one city councilwoman who said, we got to give people room, or was it the mayor, room to destroy property. Uh, the police were backing off and allowing riots to happen. And, very quickly in this case, she not only filed charges, but filed really significant charges, which, as it turned out later, the evidence didn't support. And I think that her mistake was listening to political pressure to make prosecutorial decisions, making decisions without enough evidence, making charges that would be politically popular with the group that she was catering to, and then ultimately, obviously, failing to deliver. Um, and it's often said that prosecutors overcharge cases, whether they have to do with policemen or anything else. And to the extent that that's true, that's not a good thing to do. It's better actually to initially undercharge a case because you can always add charges as you investigate. You need, in a case where you're pretty certain that you are going to have a case that's going to lead to a felony charge and a felony prosecution, um, you need to file enough to make sure that the person doesn't get away, that the person is held on, an appropriate bond, and then you continue to investigate the case. The case, we continue to investigate cases right up till the day of trial. Sometimes even during trial, new things come up. And you can always, after you've made an initial charging decision, make it more serious. But if you start out with, as she did in this case, murder, this is a murder case. You can't really retreat from that very easily. But I think that there were numerous mistakes, many of which I think are due to inexperience, and some of which are due to um, just politics, just making a decision because of political pressure.
As a sidelight, we should point out that that same mayor of Baltimore who said we need to give these people room to riot ended up chairing the Democrats' national convention
Yeah.
because she was next in line when Wasserman Schultz stepped down. And there was very little media mention of who that woman was who was taking the place. But story for
Right.
another day. And then compare and contrast when we had the decision from the Attorney General's office here in Idaho on the council shooting and the evidence that was released. I mean, how public
Hmm.
Lawrence Wasden was about this, and perhaps didn't even need to be that public. And then within a couple of weeks, there was another uh, additional drop of evidence, or at least public drop of evidence, where
Hmm.
he showed people what had taken place and the like. I guess it's an entirely different sort of approach to what was done in Baltimore.
Right, and it's, obviously different circumstances, but some of the same factors were involved. And in the case that Wasden investigated, there was a lot of political pressure on that one too. There was, um, there were a lot of competing facts in that there was testimony from one side about this and from another side about that. There were some physical facts. There was a DUI or an alcohol breath test that was or blood test that was taken that he released the results of. And what he did was and it was subject to enormous criticism from certain circles, but he took a long time to look at it. He gathered a lot of evidence. He seems to have put it all together and thought about it carefully, and he's issued a very um, detailed report about why he took the actions he did. And the conclusion that he reached after looking at everything was, you know, there are two sides to this. But in the long run, what I have to do as a prosecutor is decide whether there's evidence that I can take to a jury and, present credibly and possibly obtain a conviction. And he concluded that he did not have that evidence. And again, I'm speaking in both of these cases about, cases where others have far more information than I do. But, the approach of taking it slow and actually looking at all the evidence and refraining from early and significant discussions about the evidence is always a good one.
And I was going to say that the fact that he was the challenge I thought that his office had to deal with. And there are two sides to every story, but there were multiple witness accounts that diverged,
Right.
and so it was multiple stories they were
Right.
hearing. And if you can't get any sort of agreement from all of these witnesses, and everyone is seeing something entirely different, maybe they're at a different angle. I don't
Mhm.
know, but you really can't say that there's no cohesive evidence here that was taking place.
Well, that was certainly the gist of his report on it, and in addition to which he had some physical evidence and some evidence that wouldn't really be contradicted, um, like the alcohol evidence, and um, you know it, you have to weigh all this. I mean, if I have three people saying one thing happened and three people of equal credibility saying another thing happened, that's not really something that is going to yield a jury verdict. And another thing people need to keep in mind when prosecutors make decisions to not prosecute, um, that leaves open the possibility that evidence will come out sometime later. If I say I don't have enough evidence to prosecute this robbery because so and so was hit on the head and he was dazed and he didn't really remember it, and the other guy says it didn't happen, and I charge it and I go to trial and I lose, that's it. If, on the other hand, I say there's not enough evidence at this time, and later on I get a cell phone video that shows what happened, then I can prosecute it and then I have evidence. So proceeding when you know you don't have enough is never a good idea. And I think when it happens because people are responding to political pressure. And I think that's probably what happened in large part in Baltimore. Um, and, I don't know whether there would have been more evidence or there would have been a different charge that could have won a conviction in those cases. But proceeding with the evidence they had and the huge charges that they filed obviously led to a real problem.
How often do you have 10 people come along and say, man A shot defenseless man B, who in man B was making no threats? I would imagine you never have anything quite that cut and dry.
Well, often we have pretty good evidence, but something that cut and dry. People say, sometimes sarcastically, sometimes in closing arguments in trials, we don't bring cases which where people committed these crimes in front of priests and nuns and bishops. I mean, it just doesn't usually happen that you have 100% solid evidence against a person and there's nothing on the other side. So you always have to cull through everything you have and assemble a case carefully, and that takes time to do.
There was a video, a body cam video of the shooting in Milwaukee. Learned about that this morning when I was watching Fox and Friends. And there was a question that came up. Well, how soon will the folks in Milwaukee release that? Well, my guess is until they sort all of this out and there's an investigation going on, you don't make the video generally public, do you? Until you actually, because there's going to be potentially at least a civil case, if not a criminal case, going on here.
Well, they shouldn't. Again, often for because of political pressure, people do release things that they shouldn't release. But in general, if a case is ongoing, if a case is being investigated, um, or if a case is investigated and you conclude that there's a case to file and you take the case to court, you don't release the evidence to the public for all kinds of reasons. You don't want to taint the jury. You don't want to sensationalize it any more than it might already be. The evidence is often, individual piece of evidence is often misleading and doesn't tell the whole story, whereas the entirety of the case file does explain the whole story. And it often makes it difficult to continue the investigation if you keep leaking out everything that you get as you get it. So the general and certainly the preferred policy among prosecutors and police is ongoing case, don't release evidence. You don't release it to the public. You don't release it to anybody who's going to take it to the public, and you don't give copies of it to anybody. The only people that would have it would be the prosecutor, the police, and then access is given as is appropriate to other people who have a need to know, like maybe to a witness. You might show a witness a piece of something. You don't give them a copy to take home. You might show the victims what there is evidence-wise in the case, but you don't give them a copy to take home. So there is no real advantage to publishing your case before you get to a jury because the jury is the only group of people that actually has anything legally valid to say about it.
We have more with Prosecutor Grant Loebs on the way. If you have a telephone call for the prosecutor, save that because we have a break and I don't want to leave you on hold for the next 3 minutes. But we've got, in fact, he's here for the entire hour. So if you have a question or comment, the number is 736-0300. You're listening to Top Story on News Radio 1310 KLIX and newsradio1310.com. It's 67. Bill Colley with you as well at 920. Our studio guest this hour is County Prosecutor Grant Loebs joining us on his monthly visit. And if you have a comment or question for him, remember the telephone number is 736-0300. He's here until 10 o'clock this morning. That's 736-0300. Bill Colley with you as well on Top Story on News Radio 1310 KLIX, newsradio1310.com at 68. It's 924. Quickly, as long as you're here, I've got to ask you about this story I showed you from the New York Times earlier, which was a link I found at
The air conditioning?
that there's a push now to put air conditioning in a lot of the nation's jails so we can make the inmates. Now, my school, when I was in school growing up, we didn't have AC, and yet now there's a push to give prisoners air conditioning because some of them say it's too hot.
Well, yeah, I mean, I know that over the last year they've been putting air conditioning into Twin Falls High School for the first time, and my son was kind of distressed that they waited till after he was done to do that. And my daughter says, "Well, I'm almost done, and I'm barely getting it." But of course, during the summer months, the school is out, so the air conditioning isn't needed. I don't know what to say about that. It's just part and parcel of a long and sustained um, effort by certain people to make sure that um, we all feel appropriately sorry for people who are in prison. And I think that we should and do treat people in prison humanely and properly. We feed them appropriately. They have appropriate recreation, and I guess I'm not against air conditioning, but it's a financial thing. These buildings were built a long time ago, and you can't expect them to have air conditioning overnight. Now, should they put air conditioning in? I don't know, probably. I mean, it could be 110 in some of those buildings, and it could be unpleasant. But I think that by and large, we treat prisoners quite well in this country, and I'm not opposed to that. They are, in the custody of the state, and when you take a person off the street and you take them into your custody, I think you have um, the responsibility of treating them humanely. I don't think you need to go overboard. I don't think it needs to be like the prisons that I've seen in Norway and Sweden and places like that, where, you know, I wouldn't mind vacationing in some of those places, I think. But I think that by and large, with obvious some outrageous exceptions that we've all read about, we do a pretty good job in this country.
We have a caller with us. And caller, you're on the air at 926 with Prosecutor Grant Loebs. Go ahead.
Yes, Julian Assange keeps saying that he has information that would indict Hillary. I just wonder what would it take to actually indict her in this situation with an Obama Justice Department and Loretta Lynch. I mean, it would have to be something extremely strong, I would think. I'll hang up.
Oh, I think it would have to be ironclad. Um, maybe some policeman has a body cam video of her, pulling a gun and shooting somebody. I mean, I would hate something like that. I mean, I don't mean to be too flip about it, but the fact is that after watching the FBI director make his presentation where he laid out absolute, with absolute precision that she had violated numerous federal statutes, and then said that any prosecutor would have to be crazy to prosecute her, even though she was clearly guilty, because there wasn't intent when, of course, the statute he was talking about was not a statute that required intent. You know, I have no confidence that there's any chance that she'll be indicted. And I think it's in part because the court system doesn't want to, decide the election. I think it's in part because Obama's president and he doesn't want to give an election to Donald Trump. And I think it's because, in general, the Justice Department um, doesn't go against big political people for what they view as kind of political kind of crimes. So I can't imagine it. And, as with all of these things we've talked about tonight, where I'm talking about cases in other jurisdictions, I don't know what all the evidence is, but I'm going on what the FBI director said. And he laid out a case for prosecuting her and then said there's no evidence. So I can't imagine.
We're going to try to squeeze a caller in here. We've got about a minute before the break. And caller, if we don't get a chance to answer the question right now, we'll do that on the other side of the break. But go ahead. You're up next on KLIX.
Hey, good morning. And Mr. Loebs, I know you're in the Republican Party and all this and all that, but yesterday when I was listening to the Milwaukee county sheriff, and he was talking about and blaming it on the liberals and whatever it means and whatever it is. But actually, it's been disproportionate, the arrest in LA and in Baltimore and all the some cities where there's a lot of ghetto, it's ghetto and it's poverty written. It's been known and it's been fact that since the private prisons have been open and are operating, people get longer sentences. Is that right, or am I wrong on that?
We'll have to answer that on the other side because it's break time. Thank you much for the call. It's 9:30. Grant Loebs is in studio with us. He's the Twin Falls County Prosecutor at 68. And the question is that we'll talk about coming up in the next half hour. Do minorities, especially from inner cities, are they more susceptible to arrest, and do they get longer sentences? And that may follow, of course, the thinking that perhaps the justice system might be a little biased. We'll have an answer to that coming up in just a few minutes on News Radio 1310 KLIX. Our studio guest is the prosecutor from Twin Falls County, Grant Loebs. He joins us on, I think it's the third Tuesday of every month. I'm not counting necessarily, but this is the third Tuesday. And we had a caller a couple of minutes ago here at News Radio 1310 KLIX and newsradio1310.com who asked some questions related to, I think, conviction rates for minorities as well as the length of sentence, and made at least the assertion that minorities get longer sentences. And there's a lot of evidence out there that's conflicting, I suppose, on all of this.
Yeah, I think there's some evidence that shows some of what he was saying, and he started his question by admitting that I'm a Republican, and so I may not, I assume, be able to answer this objectively. But I would just point out that number one, the I don't think this is a Republican or Democrat issue. And number two, the sheriff that he was talking about in Milwaukee, or the police chief, he's a Democrat, and so the question for law enforcement is not really a Democrat or Republican question. The question is, how do we respond to crime, whether it's in, the inner city or whether it's out in rural Idaho. And there's only really one proper way to do that, and that is take the crime, look at it according to the evidence, analyze it according to the law, and charge people when you believe you have a case against them, and ask for appropriate punishment. Now, clearly, if you're an inner city prosecutor, most of the people you prosecute are going to be inner city people. Most of the people you prosecute in the inner cities are going to be victimizing other inner city people. Now, are they going to be disproportionately minority? That depends what the population of your inner city is. Um, as to the question of whether or not there are disproportionate sentences, I can't answer that with, my finger on all the data because I don't have that with me. But sentences are calculated according to the crime, according to the criminal record of the person, and according, as best as we can figure out, to the character and the future threat of the person. So if you have a person who, doesn't have a job, has 15 prior convictions, and who, when asked by the pre-sentence investigator, says, "To heck with you, I just want to do my time." Um, if that person is a white person living in rural Idaho or living in, the Upper East Side in Manhattan and in a penthouse, he's going to get a serious sentence. If he's a minority person, he's going to get a serious sentence. Now, if there are disproportionate sentences among similarly situated people, and the disproportion is based on race, then I would be the first to say that should not ever happen in this country. But I think we have to be careful in making accusations against the system and against particular people in it by just using massive, statistics and databases. You have to actually mine down into the details of the case because in every case it is its own world. You can't say, 5 years ago I prosecuted a Hispanic person and he went to prison for 25 years, and this year we prosecuted a white person and he only went to prison for 10 years and they were charged with the same thing. You'd have to know exactly what the facts were in those cases and what the backgrounds of those people were. And, my attempt always is to make sure that similar crimes committed by people similarly situated get similar punishments, as much as I can, you know, dictate that by making recommendations. But, I'm not saying that he's wrong in looking at some of those statistics. I've seen some of the same ones, and they are a little troubling. And what you need to do is find out more detail about them.
We have time for a caller, perhaps. Nope, caller's going to bag it on that. I guess they're going to try to get in on the other side of the break. We've got about a minute then before the next break is coming up. Prosecutor Grant Loebs is in the studio with us until 10 o'clock this morning. Telephone number 736-0300. It is 67. Bill Colley with you as well at 9:38. The one question we had about the Clinton people, there's a lot of discussion that I've seen that says that the Clinton folks, if they didn't necessarily break any laws, what they've done is tremendously unethical when it comes to how they've run their foundation. And there's been a lot of embarrassing emails in the last couple of weeks and other things coming out. Will we? I guess the question is there? That I think I phrased it to you this way: unethical, illegal, or is there a little of both?
Well, I don't know that we for sure know that because so much of the evidence has been destroyed or tampered with or hidden. And what evidence there is in the control probably of the FBI. And if they are investigating it further, then maybe we'll hear more. If they're not, then we probably won't ever see it. But the only real investigation that's been done into that has been done by Congress, and they have the power to subpoena and investigate people, and maybe you'll get more public information that way. But um, you know, who's to know? I mean, the information is held by Hillary Clinton, and some of it was turned over to the FBI, but not all of it, because a lot of it was deleted by her own admission.
And if the Russians help us out with finding it, maybe things change.
Yeah, I'm not going to ask the Russians for any help with anything.
20 minutes away from 10 o'clock. We'll take more of your telephone calls, too, coming up after the break. Grant Loebs is the Twin Falls County Prosecutor. He's in studio with us this morning. Bill Colley with you as well on News Radio 1310 KLIX and newsradio1310.com. Got about 15 minutes before 10 o'clock. We'll call it actually 9:44. It's 68. Bill Colley on Top Story on News Radio 1310, KLIX and newsradio1310.com. I want to thank you for joining us. On a monthly basis, Twin Falls County Prosecutor Grant Loebs joins us in studio. And again, he's here today. The telephone number is 736-0300. And we have a caller with us coming out of the break. Caller, you're on the air with the prosecutor. Go ahead.
Hello, Bill. I was calling and try to talk to the prosecutor. How petty of a crime is too petty?
How petty of a crime is too petty?
Correct.
Why don't you explain what you mean by that?
When the sheriff tells you that the prosecutor won't prosecute it because it's too petty, it's still a crime against you if you've had something stolen. Say it was 3 cents. How petty of a crime is too petty?
Well, I don't know. The sheriff, hopefully, and his deputies hopefully are never saying that. They should never say that. Their job is to investigate the crimes, and if they write up a report and they bring it in, the caller is right that if it's a crime, it is a crime. Now, sometimes it's a crime, and the criminal system is not the best place to adjudicate it. Sometimes it's technically a crime, but it's not something that anybody really prosecutes generally, and to prosecute it would be a a waste of everybody's time and of valuable resources. But that usually is something that we decide, if we decide that, based on getting a report from a sheriff's deputy or from a policeman. So in general, there aren't any policies in my office, and there may be different in different places, that we will not prosecute a whole range of crimes, because the facts of each crime are different. What might seem to be to use the caller's words, a petty crime might be a serious crime when you take a closer look at it. And so it's hard to answer that question. I mean, yeah, if somebody went to a convenience store and when the clerk wasn't looking, stole 3 pennies from the, take a tip, leave a tip jar and walked out, I'm probably not going to prosecute that because there isn't any serious harm. There isn't any interest in the state to expend, maybe thousands or more dollars in prosecuting someone for taking 3 cents from a, leave a tip, take a tip jar. But if somebody steals your car and your car maybe objectively, maybe to somebody else looks like a piece of junk, but it's your only transportation, nobody should call that a petty crime. It steals from you something that is very valuable to you. So we try to look at these things, again, using all the facts and all the evidence available. And there isn't any whole range of crimes that are too petty to investigate.
Well,
But the police need to, to conserve their resources as well.
do we have a mediation process? Let's say somebody grabs Mrs. O'Malley's pie off the windowsill while it's cooling and eats it. Do we have a mediation process too where we could go to instead that would just say make restitution versus having a prosecution?
There is a formal mediation process that can be used. It's not used very often in criminal cases, but it can be. But there is an informal mediation process that's used all the time by policemen in the field who say, hey, buddy, you stole this guy's ballpoint pen, give it back, and, go about your own business. I mean, sure, you could charge somebody with a crime there, but police try to mediate those things in the field. And there is Similarly, a mediation process like that, once they bring the case to my office, sometimes they'll bring a case and, you'll look at it and you'll say, this is simple to solve. There's no damage done to the property. Give the property back, pay the damages, and, go on your way. And, if you stay clean for 6 months, we won't prosecute the case. So there are ways that we can do these things informally. There's a sizable body of informal adjudication like that in the juvenile system. Much more is done informally in the juvenile system than in the adult system. But there are places along the way for police, for prosecutors, and for even sometimes for judges to do things that are kind of informal, so as not to make a giant deal out of a little incident. But that requires you to investigate the little incident. It's possible that what looks little is in fact big to somebody. Like my example with the stealing the car that looks like it's three-quarters of the way to the junkyard might be your only car, might be your only way to get to work.
949, Grant Loebs in studio with us on KLIX, and the telephone number 736-0300, 736-0300. If I could add to that, too, you mentioned mediation. I think when I first moved to Idaho, first newspaper story I ever saw was about the drug court. And there's been an effort, I guess, made realizing that a lot of people are first offenders, and it's not necessary, if they can get some treatment, it's not necessary to run them through the prison system and turn them into a hardened criminal.
Right, but drug court isn't that anymore. Drug court used to be a place where first-time offenders for drug crimes would be sent, and in lieu of going through the regular process, they'd go to drug court, they'd hopefully get cured, they'd go back out and get jobs and become productive citizens. Drug court is now for the more serious offenders who, if it weren't for drug court, would probably be sentenced to a prison sentence. And that is a substantial philosophical change in what drug court is. But in Twin Falls County, my office has created an alternative that's like the old drug court. That is, if we arrest somebody for a felony drug crime and it's fairly minor, it's personal use, it's not delivery or selling to other people, and we look at the person's record and they have really no record at all. This looks like their first run in with the police system. Then we offer them what old drug court used to be. Go and get yourself treated, get yourself healthy, get back out there and become a regular member of society again, and we'll dismiss the charges. But that is, like I was talking about before, one of these kind of informal ways of handling a case rather than taking everybody through, trial and sentencing and putting them in jail or putting them on probation. And there are a lot of instances where we do that with various types of crimes.
951, we have another caller with us. Caller, you're on the air with Prosecutor Grant Loebs on KLIX. Go ahead.
I'd like an explanation on contempt of court and why so many times they aren't pursued, charges aren't pursued by lawyers. Thank you.
Well, contempt of court is maybe a lot of things are under that. You can refuse to answer questions. You can refuse to show up. You can refuse to abide by a judicial order. Some of those, like refusing to abide by a judicial order, that may be a civil order. So, you may be involved in, say, a divorce or a child custody case or, a dispute over property with your neighbor. And the court may issue an order that says, do this, do that, or stop doing this or that. And the person may do it. And in those cases, the contempt of court proceeding has to come from some civil person, whether the individual themselves or the the individual's lawyer. In cases like in criminal cases where let's say I put you on the stand and I ask you questions and you refuse to answer, and the judge says you have to answer, and you say I refuse to answer. Well, do you have any constitutional basis for refusing to answer? No, I just refuse. Well, then I'm going to hold you in contempt for not answering. Sometimes the contempt of court punishment is fairly swift. The judge will say, I'm going to hold you in jail until you answer the question. So every one of these things is very fact specific, and whether they are pursued Sometimes it depends on the judge, sometimes on the prosecutor or the police, and sometimes on the individual who believes that a court order has not been followed by the other party.
We have another caller with us. Caller, you're up next at 9:53. You're on the air on KLIX. What's your question?
Well, my question, morning, Bill, morning, Mr. Prosecutor. You've been in the prosecutor's office since '97, and I've been looking for an individual. I'm a local author doing research, trying to find an individual who went to, essentially, he was busted. It was Buzz's former owner. Buzz was a second police dog. I've been trying to find this individual for 3 years. What I understand was it was close to trafficking amounts, but yet I've been unable to unearth him in the prison system. My question is, how likely, and this individual, according to records, was well known to law enforcement, I've been trying to ascertain how he could have not gone to prison. Now, you were in the prosecutor's office in the mid-'90s. Was there not the emphasis that you're going to the clink, you're a known ne'er-do-well, or I guess I'm looking for percentages, or is it possible that this individual didn't go to prison? And that seems very unlikely to me.
Well, of course, and you're free to call my office and talk to me about this case in detail if you have more information. I don't have enough information from your question to answer it precisely, but there has not been a difference in the prosecutor's attitude toward these cases. Each case, as I've mentioned, is its own case. I do not know whether the person you're talking about went to prison, went to probation. Sometimes, significant drug cases are taken over by the federal prosecutors if there is a federal issue involved, and sometimes they are indicted by the federal prosecutors in federal court, and then they go through the federal system, and you couldn't find them if you searched for them under the Idaho system. There have been several cases over the years where the federal government has taken over prosecution of local cases, and people have gone to federal prison. And if you typed in the Idaho case, you'd find out that it was dismissed and transferred to the federal government. I don't know exactly what case this is you're talking about, but you're right. I was in the office. I've been in the office since '94 and been the prosecutor since '97. So it's likely that we would have some information about that case if it, in fact, there was an arrest and a prosecution made. And to the extent that I can, if you call the office, give me some facts or drop by, I'd be happy to help you with that.
I want to thank you for the call. We've got a couple of minutes before we wrap up. 2 callers ago, I guess it was, the caller was asking about contempt and why some people don't end up in trouble. And it struck me, I remembered an old TV show called Barney Miller from back in the 1970s and 80s. And there's an episode of the show where a fellow shows up at the precinct house, and he had been a wanted criminal during the student unrest in the 1960s. And he walks in after being on the lam for about like an Abby Hoffman type of
Yeah.
take. He walks in after being on the lam for a dozen years and says he wants to surrender. And the FBI says we're too busy to come pick him up, let him go. And because it's no longer a concern. And I'm sure that happens in law, doesn't it, from time to
Sure.
time?
Part of what we do in law enforcement in Twin Falls County is we try to assist other law enforcement agencies in other jurisdictions. So if somebody is wanted on a warrant in Florida, for instance, and they get stopped in a traffic stop in Twin Falls County, they will be arrested on the Florida warrant if it's an active warrant. We'll bring them in, we'll put them in jail, and they'll get a hearing before a judge where they're told, you were arrested on a Florida warrant. My office then tries to find out from the Florida authorities, what do you want him for? Do you want him still? Will you come and pick him up? It's not at all unusual for especially those distant jurisdictions to say, if we picked him up here in town, we'd be fine with prosecuting him, but he only did this and it was a while ago and we don't want to spend $2,000 to come and get him. So yeah, forget it. And then, those people are released. And I tell a story that happened when I first started back in the early '90s. I was prosecuting a case, and I think it was a misdemeanor case, and it turned out that the person that I was prosecuting was wanted for a car theft in California. So I called the prosecutor in, I think it was Orange County somewhere, and I said, "Hey, we got so and so here. I've got him on. I think it was a DUI or driving without license or something. And it looks like you've got a warrant out for him for a car theft in your county." And he laughed and he said, "Car theft? We don't bother with car theft. We don't have enough people to mess with minor stuff like stealing cars. I'm up to my eyes in rapes and murders, and I said, wow. I mean, and so it does matter what jurisdiction you're in.
We'll see you in about a month.
Okay.
I want to thank Grant Loebs for
Thanks for
dropping
having
by
me.
and listening, of course, to Bill Colley as well on Top Story. Rush Limbaugh is coming up next following the news at 10 o'clock. And God willing, if the creek don't rise, I'll be back here tomorrow morning between 8 and 10 o'clock.